And clients will go, oh, I might just do it myself. I'll just get something off the internet and do it myself. And it's like, please don't, because you'll be back here. You'll be back here in 5 years' time if this goes wrong, and you will spend 100 times as much money to sort it out.
So we're joined by Kelly Hudson, who's an IP solicitor.
Can't see us. Hello.
I can see you on there. Look.
Oh, and see us. There
And
you go.
the
I was going to say it's all about videos.
yeah, did you not notice them?
I did notice them. I just had a mind for.
Just sort of props.
And the MD now of McDaniels Law.
I am. Yeah.
A specialist IP
Congratulations.
Thanks.
firm. So, I mean, this is probably across the board, but in the creative
Yes.
industry, IP usually only comes into people's heads when someone's nicked something from
Yes.
them, one of the ideas or designs. So I thought it'd be good to get to speak to you about IP, what it means, what it
Yeah.
is, how people can protect themselves, how they cannot infringe
Yeah.
other people's IP, maybe accidentally, maybe not.
Yeah.
So we're in good hands, I think, to have this conversation.
Expert hands.
Oh, thank you. That's
Yeah.
very kind. Yes, and I think you're right, or certainly it used to be the case that IP only entered someone's mind when there was an issue, and that does still happen. And it tends to be worse for a lot of businesses we see when that's the case. There is more awareness of IP now and of its value, because for a lot of businesses, such as yourselves, actually, IP is the core of your entire business. That is what it is based around. You create original artistic work.
It took us a long time to realise that,
Yeah.
because there was a point where we used to think we just sold our time.
Yes. No.
But if you do that, you don't really monetize your business properly. So it's
Well, straight away we're into a core issue here, I think. So we're going to talk IP because that's the correct term. Correct me if I'm wrong, but typically I would say the man in the street would talk about the copyright of something.
Yeah.
So obviously it's the same thing from a practical perspective. So it's not an ongoing problem, but it's definitely always been kind of threaded through the business that people don't understand the basics of it.
Yeah.
So what you've just said there is from a basis of we know that
Yeah.
doesn't matter who's commissioned us, who's paying us, doesn't matter what the circumstances are.
Yeah.
As far as the UK law goes, we are sitting physically making the thing, and therefore by default we own the copyright to it.
Yes.
Or the IP. And fundamentally, a lot of clients don't understand that. And in a lot of cases, that doesn't matter. But you then sometimes have to have the conversation after the fact when they start asking for things to be handed over that they've assumed.
Yeah.
So I do think there's just this fundamental misunderstanding, I suppose.
Yeah.
It's not even a misunderstanding. It's people, like Kev was saying, they don't think about it until it's a problem.
Yeah.
But that is the baseline, that in this country, if you are the one physically making something, you own the rights to that, and that's just the starting position.
Yeah, and people don't want to think about it because, to be honest, it's hard. It's not simple. It's not straightforward. I did a 4-year degree and then a 2-year training contract, and then I went back to university as a postgraduate, and I've practiced now. I've been qualified for 13 years now, so, and I make a living off it full time, and I still learn things every day, and the law changes all the time. So at the minute, we are in a position where the UK's copyright law is not harmonised with Europe, and actually that is bringing a lot of argument from lawyers about us saying that things now have copyright in them that traditionally we would have said didn't.
So I know Kev's got more questions, but again, just like the fundamentals here. Can you copyright an idea? In this country, can you copyright an idea?
You shouldn't be able to do it anyway. So there's this principle called the idea expression dichotomy.
Catchy.
It is. It's dead catchy. It's really good. But it's one of the first things that you learn when you're a student doing IP law. And basically what it says is copyright arises in the expression of ideas rather than the ideas themselves. And we've had queries in the past where people think they've invented something and there's no proof.
It just reminded me of this guy that came to our office years ago. We
I knew he
might
was gonna
tell that story later. Sorry,
Well, I can tell you this story. We had somebody who thought they'd invented various TV characters.
All right.
Which there was no proof of, and I don't really know where that had come from.
Yeah.
But
He's got a strong case already.
Unfortunately, they didn't. But it was things like the Headless Horseman, which has been around for an incredibly long time.
Yeah. How old was this guy?
Yeah.
Was he 200 years old?
No, and that was part of the problem. So it was things like that, and there was no good evidence of it. E.T. was another one. Somebody thought they'd invented E.T. And there was no proof that Steven Spielberg had access to steal E.T. But we do get some queries about things like that. Like we've had queries in relation to people who've claimed they've had rights in the Olympic rings before and things like that. And that's not really a good arguable case either. So there is no copyright in ideas. It's in the expression of ideas. And then because copyright is always unregistered, if you are copied, and that's the key, is you've got to be copied. So two people can have the same idea completely independently. But you have to be able to prove that there's some means of access, and that can be your work's publicly available and it's really popular. It works like that. So, and it will arise in there's 4 main categories. It's original, literary, dramatic, musical and artistic works, and pretty much most things fall under one of those categories. There are separate categories for things like software, which has its own protection. Computer programs have their own protection as copyright works. But most things fall under those categories.
So thinking about the stages, right? So I'm thinking about an actual example that's ongoing at the minute, which is, just a client conversation we're having. So in a meeting, we said, oh, well, actually, if you're looking for something that'll achieve this goal, why don't you make a film like this?
Yeah.
And just as I'm sitting talking to you now, I was like, I pitched it, basically, right? So at that stage, there's no copyright.
Well, and
because I could have had the same idea as someone else was having 3 doors down at the same time at that point.
But that doesn't mean that you haven't got copyright in your idea.
But it's just, okay, on a practical level, I'm just talking. So
Yeah.
I haven't...
It's it's arguably not expressed in enough of a form for there to be a copyright there
so the next stage I went to was then to write down, literally, just in an email, an outline, just slightly fleshing out, but to say, the film would kind of follow this path, would show these kinds of things.
Yeah.
So that's all that is. So that's, by the sounds of it, the beginnings of, if there was ever any query down the line, the beginnings of a copyright case. The next stage I'll go to from there, which we haven't got to yet, but that will be the next stage, is their feedback on that. And then I'll go, now I'm going to write an actual script, which I'm putting time into, obviously, research, their company and everything, and make sure it's in the right tone of voice. So that's obviously moved on a bit further. The next stage from there, if they're happy with that, is then we'd create a storyboard. So obviously, by the sounds of it, each of these stages further strengthens any potential claim on copyright further down the line, because we've expressed the same idea in more detail every time and in a different format.
Yes, but in every document, there's a separate copyright in every document. So there's a literary copyright in the first email. There's then artistic copyrights in the storyboard. If there's a script, there's a literary copyright in that. And something that should always be in your mind as a creative business, especially if you work on commission, is then how much involvement you have with your client. Because the basic rule is the first owner of copyright is the author, the notional author. If you are commissioned to do something and they just say, this is what we want, you go away and come up with ideas, then you've come up totally with the idea, that's your copyright. If you have worked collaboratively with the client, you can have more than one owner. So you can be joint owners of copyright together. So it can be hard to pick out exactly what people have done and split that out. And in general, if you are joint authors, both or however many joint authors there will be, are entitled to use and access the whole of the work. But you need to have the permission of the other owners as well. So there have been some recent cases about this, some recent judgments about it. I'd have to get the name, but there was one that involved a YouTuber who somebody else had written scripts and had helped them with scripts, and it was to the extent that that person was co-author, and then there was an argument that if they were a co-author, they didn't have permission to keep the videos up online and they should have been taken down. So there is a lot of debate about it. And there have been some big cases around rights of joint authors. And it's also relevant that you can infringe copyright, obviously through a different medium to which the original work's recorded. So you could write a book, and there's a case, and I've forgot the name, but there's a case about a football fan of, I'm sure it's either Darlington or Middlesbrough Football Club, I think it's Darlington, and it's the story of this disabled guy who was a fan of the club, and it's related around that, and there's a book on it, and somebody, that was infringed through somebody then making a record, like a TV recording.
It's like an unauthorized adaptation.
Yeah, basically. But that infringed the copyright in the book.
Yeah, of course.
So you can do things that way. So it doesn't need, and the test is, have you copied the whole or a substantial part of the work, of the earlier work? And that's not quantitative, it's about the quality. So it could be a small part, but if there's enough quality and there's original independent thought, and you've created something that uses skill and labour, you will have copyright in it. And actually, there used to be a de minimis rule on copyright where the courts had said, well, that's too small to get protection. That's pretty much gone now. We had a couple of cases. There was a European case called Infpac, which was then followed in the UK by a case called Meltwater. And there was another case called Newsbin, I think. But basically about headlines, newspaper headlines, and some of them 2 or 3 words, but were enough to have copyright in them.
Wow.
The copyright in a headline, not in the article itself.
Yeah, like headline clips. So it could be very short number of words. But the thing with headlines is there is a lot of thought that goes into them, because it's how do you catch people's attention in 3, 4, 5 words.
Yeah.
So actually, the creative effort is there.
Yeah, that's true. You could argue because there's so few words, that's the art of it.
It takes those poor lads at the Sun and the Mirror ages to come up with those awful puns, doesn't it? Yeah.
It
Well,
does.
here's a question then. What can creative businesses do to protect their IP then?
Hire Kelly, obviously.
Yeah. Well, the most important thing is to be informed about what rights you've got and what you are creating. And that's not meant to be some onerous task of go away and look it up. But there are, for example, trade organisations dedicated to helping people with this sort of thing. So one of the trade organisations we work with is an organisation called ACID, which stands for Anti-Copying in Design. And they help people recognise their unregistered rights and protect them. And we are one panel firm that works with them. There are a few. But if you wanted some advice about what rights you had, and you were an ACID member, you could ring, and they would put you in touch with me or a colleague, and we would tell you for free. We would talk to you about it for free and tell you what rights you had and what you could be doing to protect them. So to be informed is the most important thing, without a doubt. And then obviously some rights you can register. So think about registration. So if you design products or you design anything that is a 3D article, you can register a design right for it. It doesn't necessarily even need to be a 3D article. It could be 2D. But you can register a design. It's very cheap to register designs now. Official fee in the UK for up to 10 is £70. So it's really, really cheap. Actually, yeah, it's £50 for 1 and £70 for up to 10. You can register trademarks. So if you have a business and are trading, you are building goodwill in your brand name from the minute you start trading under it. Trademarks are really good rights because you can have unregistered trademarks that build huge amounts of goodwill in them. And you don't need a registration, but actually they're cheap in relative terms. Certainly in the UK they're cheap. They're not cheap in some countries.
To ask the dumb question here on trademarks, does that have to mean, say, a logo, or is it a wider definition?
It's wider. So it used to be, and they've taken this requirement out, so it used to be any sign capable of graphic representation, and in the graphic representation requirement has now been removed from the Act, and it's any sign capable of distinguishing the goods and services from one undertaking of another, and that's what the Act says. In theory, you can register like smell marks, in theory. I don't know if you would get one in practice. You can register sound marks. there is the score, and a lot of brands actually do make good use of sound marks.
What's the minimum number of notes that you need to qualify?
I don't know. I don't think there is a set minimum.
Really?
No, there's no, not that I'm aware of. There's no set minimum. But like smell marks, there are some that are on the register. So there is one that was always sitting there for the smell of freshly cut grass, was registered for tennis balls, and that was on the UK register. I don't know if you would get one now. They're called olfactory marks, and they are very, very difficult to get. Whether you could is another question. But yeah, so as I say, you can have music marks, anything. The best trademarks are trademarks that, from a lawyer's perspective, are trademarks that tell you nothing about the brand itself. So Apple is a really good one. Even though now when you say Apple, everybody thinks of technology. Actually, when it started, nobody thought, oh, that they make computers. Mm-hmm. You would have thought you were talking about fruit. Mm-hmm. So those are the best ones because they are what lawyers call inherently distinctive, i.e. nobody's going to object and say that's descriptive. Mm-hmm. So a good example of a trademark that is now distinct but was descriptive and was refused registration at first is WeBuyAnyCar.com. And then they went off and did huge amounts of marketing with those really irritating songs. Mm-hmm. Everybody knows who they are. They now have a registered trademark.
Everyone who's watching and listening to this is now hearing it in their head.
You do, yeah. But that's very effective marketing. And they got a trademark in the end for WeBuyAnyCar.com. But it took a while. And that's the objection that you will sometimes get from the registry is that is descriptive of what you do, and somebody else should be able to use that. So the government will not give you a monopoly on something that other people should be allowed to use. Mm-hmm. But that's obviously a second type of protection which you can get a registration for. But unregistered trademarks develop goodwill anyway. So just as long as you are trading and building that goodwill, you could stop somebody else from using it. That's called passing off, and it is probably a more onerous infringement to prove than trademark infringement is, and that's because you have to show a likelihood of confusion that can lead to deception, which you don't have to show that.
We actually have personal experience of this.
Yes, you do. So it's not required for trademark infringement. If it's an exact replica of the mark in trademarks, which we call double identity infringement, it's like lawyers think, amazing, this is a really good day out, this will settle really quick.
By which you mean 6 to 9 months?
Yeah, 6 to 9, yeah, probably 3 or 4 years later. But no, basically in those cases, the other side should give in because it's not arguable. If it's the same mark on the same goods and services and there's a registration, you don't need to prove that there's a likelihood that anyone's confused. So you should win straight away. As I say, passing off is more difficult. But then with things like copyright, the key is to just keep records of what you're doing and when you're doing it, for example, so that you can say, well, I did this first. And realistically, you could know about it because I launched it at this time, or I was at this trade show, or I advertised it this way, or I had this client, and you've then spoken to them, so there's that link there. Mm-hmm. So it's just about good record keeping is a big part of it. And we used to have this thing years ago when I first sort of was coming into law where people used to post things to themselves.
Done it myself.
Done it myself, with a script.
Yeah.
You're going to tell that was
it's not
nonsense now.
Yeah.
Thank you.
The courts don't like it. The courts never liked it because people would turn up to court with their sealed envelope, dated, postmarked, and then open it, and inside it just wouldn't be the smoking gun of evidence that they wanted it to be. It just wouldn't be that. And that was unfortunate. So yeah, that's not, and now that we're living very much more of a digital world, actually, you just keep digital records of things, and that works.
So email
just
chains
as well.
are
email
fine.
chains are really good. Even like dated files and stuff. Mm-hmm. But one thing that concerns me now, which I've noticed, is on photos on iPhones, you can change the date that the photo shows up as having been
on the
taken
original
digitally.
metadata, can you?
Yeah. I was going to say you can probably change it in your phone, but probably
phone.
Somewhere in the metadata is buried the original date, is it?
It will be, but then it puts an extra stage in it for lawyers because you would then have to have a forensic report on the phone if you doubted that date was real, and that it just increases costs and makes it worse. basically.
We were just talking about a common occurrence at the end of projects that we have. So obviously it's video production, animation, that kind of thing, where you've got hours or days amounts of like labour that's gone into using the software to produce the thing. You deliver the deliverables to the client. There's the bill. And then the client will just casually say, yeah, that's great, thanks. Can you send me the project files now? Is that problematic from your point of view? Is there a reason why we might say, well, no, we don't really want to do that?
What do your, and this is a big thing, what do your terms and conditions say about that?
Well, our terms and conditions, unless people are really specific about it at the start, or that the IP is ours, therefore by handing over the project files, essentially, we're giving them all the tools and all of our work.
The terms and conditions don't specifically mention project files. Maybe they should, but they do talk about the IP and say that we've got two different versions of the contract, depending on various factors. We decide which one to go with, because in some cases, you go into it, it's just understood that you are going to assign the IP at the end of the project, and that's fine. But that's the least common. But it doesn't specifically mention project files. And also when the clients ask, I don't think, I was going to say 9 times out of 10, I don't know if they're ever thinking beyond, someone's just told them, oh, can you get those? I don't think there's any attempt to like, oh, well, we're taking the copyright, but it always leads into a conversation where you have to effectively try and educate them on what the law says, and it's a bit tricky.
It is, and it's at your discretion, and if the terms are silent on it, it's entirely up to you, and you're within your rights to say no, because the terms say that you retain the IP in a normal arrangement. So you could say, well, actually, there's no agreement that I'm going to give you those files. And if you decided that you were going to comply with the request, I would then have the conversation where you educate them and say, but you do realise we own the copyright, so any commercial use by you of these files will infringe that copyright. And if you share these with a third party, this information is not in the public domain, that will be a misuse of our confidential information that belongs to us. So information can be inherently confidential by the nature of it, or you can express it to be as such, which is easier, but businesses will know that some information is inherently confidential, there's no doubt about it. So they will then have an issue if you've done that, and it is entirely reasonable for you to say, we're not going to give you the project files. There's no problem in that.
I think to be honest, I think most clients ask because it's probably an urban legend about a web designer in the past. This is the story I always hear. Well, the guy that made a website was just a one-man band. He designed the website. Then after 12 months, he asked for the same money again. Or he would shut the whole thing down. Because I didn't ask for the files at the start of it, So they're just kind of getting this habit of like, it's a feeling of protection almost, that they've got them. So no matter what happens to you.
A lot of people erroneously think in their minds that when they commission something, the IP is automatically theirs. That is not the case. And it used to be the case that if you commissioned a design as opposed to copyright, the commissioner did own the design. And that was the law up until a few years ago. And then actually it was changed to mirror copyright law, whereby the rights stay with the author, the person who's been commissioned. And for example, there's a big case that relates to Dr. Martens and the logo for Dr. Martens, which is obviously an artistic work that they commissioned somebody, it's Griggs and Evans, to do that logo. And then the guy tried to sell it to somebody else. Years later, I was out flogging his wares on the market, and Dr. Martens said, that's our logo, what are you doing? We own that. And he went, no, you don't. Copyright work, I own it. So, big court case, hundreds of thousands of pounds later, judge said, actually, yes, you do own it, but in equity, it's equitable that Dr. Martens should own it. That's the only use really to it is for them. You're up to no good here. That's why it's not fair that you should keep it. So they
because unless he's selling it to try and sell it to another company also called Dr. Martens, like it has no value to anyone else.
Well,
really.
I don't know if it was I can't remember off the top of my head if it was the name or if it was a drawing of the logo.
Oh, okay.
So they got it, but it costs them a fortune. So actually, for both parties' perspective, in a creative industry like that, where you are creating something that is ultimately governed by copyright on commission or a design, you are better to have something in the contract just so everybody knows where they stand at the start. And that's where we see a lot of problems. And the worst problems really are where people have worked together and then fallen out. Where it's straightforward copying, so some third party has copied your design, tends to be easier, and it's easier all around because there's no relationship between the parties that makes things, they can be really awful. They're the worst disputes for people involved. And there's no issue with that where it's a straight third party involved, but actually the worst ones we see are where there's been a contract where people have got on and then actually there's been a falling out, and they can be the messiest because contracts can be formed through, they can be written, they can be verbal, or they can be formed through course of dealings, and then you go down a road where it's just a massive mess to try and work out what a contract is between parties, and has it been varied, and you know, and it's sad as well. It can be quite sad, and it takes a lot away from people's lives. Like, I am a litigation solicitor, and I personally would never want to be in litigation. So and that's what I say to clients. Sometimes people will come and say, I need a contract, and I'll say, well, it's going to be this much, because contracts are really, for lawyers, time intensive. They take loads of time. They've got to be right, so that they can have a cost to them. And clients will go, oh, I might just do it myself. I'll just get something off the internet and do it myself. And it's like, please don't, because you'll be back here. You'll be back here in 5 years' time if this goes wrong, and you will spend 100 times as much money to sort it out. Just have the right contracts in place at the start really, really makes a difference. Yeah. And it's key.
Good advice.
It's not fun advice, but it's really boring advice.
It's like potentially very valuable advice.
Yeah, I was going to say that. Like I said at the start, you know, it usually comes to people's attention when there's a problem.
Yeah.
So if they can be prepared, all the better.
And sometimes people can't see past that initial cost of, well, that's like £2,000 I don't want to spend, and I don't have to spend now because John, who I'm going to engage in a contract with, is really nice and we really get on and it'll all be fine.
Yeah.
And
whereas the more realistic and sensible approach is what you see a lot of time on, say, someone like Dragon's Den, where someone's invented, usually a product, obviously in this case, and they go in and they say, well, yeah, at the minute I'm, 700 grand in the hole because I've spent all this time and money on getting patents and stuff. But like, that's the thing that actually gives the investors the confidence to go, right, there's actually a business here because you've put that groundwork in.
I hate Dragon's Den for that, because like in Deborah Mead, I haven't watched it for a long time, but Deborah Meadens used to always do it where she'll go like, what's the IP? What are you doing with the IP? Have you got a patent? And it's like, you can't get a patent for half the stuff that they take on there. You just couldn't get one because it's not. Patents protect new inventions and new methods of doing things, and there has to be a new inventive step. Graham Archer could come on here, the patent attorney who we all know, and talk about it for hours. He's incredibly tall, by the way, so he'd be like, he's like 7 foot tall, so he wouldn't, I'm too short. When we stand together, it looks comical. But, they on Dragon's Den, they love that. What are you doing with the IP? Well, actually, some products that go on there are quite heavily reliant on unregistered rights. What you guys do is heavily reliant on unregistered rights. Those rights are no less strong and no less valid because they are unregistered. And that's the bit that sometimes people don't get. But copyright is a really strong right. It lasts for a really long time. If you can claim copyright in something, claim it, because it lasts a lot longer than design right. It lasts for the life of the author plus 70 years. So that's why you see, with these literary classic books and stuff, there's often notes about when they come out of copyright. So I think, and Happy Birthday, the song came out of copyright not that long ago. That was still in copyright. I can't remember who.
Disney owned that for a long time.
Yes, yeah.
Winnie the Pooh's just come out of copyright, which is why there's now suddenly horror films
made. Yes, that was in the news recently, wasn't there? That there was a Winnie the Pooh horror film coming out. So, but then also there will be a trademark over Winnie the Pooh's name, is the other thing as well. So Disney will have trademarks for Winnie the Pooh's name, and then there's an argument that you could get a trademark for the depiction of Winnie the Pooh himself. as well and sue on that basis of trademark infringement. And that's common with characters, is what big businesses will do. They will register the names and then they'll register images of them as well. Or, you know, like Captain America, there's that star, isn't there? And all of that. I'm not up to date on Marvel films because I feel like you've got to watch them all, haven't you?
You do, yeah.
And I
Too much. It's like a job.
It's too much to take
It's like
on
a
now.
job, yeah.
We've covered this in a previous podcast.
Well, yeah. We're on Marvel phase, whatever.
My next question is, like, what's the implications of people infringing copyright? Like, what can happen to you?
So there are various implications. Infringement of copyright can be a criminal offence. And from a sort of TV streaming angle, there was a lot of it in respect of, we see a lot of it around the Premier League and people being taken to court. And a lot of the original early Premier League cases around streaming and decoder cards were based on the logo, the Premier League logo, could still be seen on some of them. On these, they used to get Greek decoder cards. So it's a criminal offence, and you have agencies like FACT, and you'll have PRS for music, and you know all these agencies.
Well, there was just last week there was a case about a group of lads in London who were selling fire sticks and that kind of thing, which obviously is very common, but
made millions.
Yeah, that's what I was going to say.
Yeah.
It was how much they'd made. It was 7 or 8 million quid
Huge
over the
amounts of
course
money.
of a couple of years.
Yeah, we've got an article on our website about that actually. But yes, but they weren't actually tried in the end for. It wasn't an IP infringement. It was fraud or something related. It says in our article what it was. It wasn't IP infringement that they went to prison for, but that's a course of action that's open to them. But
just from a basic level, if you take my meaning, someone who's sitting watching one of those things is technically breaking the law, but someone who is profiting from it is much more likely to be criminally punished. Yes,
but it depends on what the focus is at the time. So we keep hearing talk, and for example, that prosecution last week has increased talk that there is going to be a crackdown on people who've just got these sticks. So you could, and you won't get the same sentence.
Yeah.
Obviously, what you'll probably get is like community service, or you'll pay a fine or something like that. That's what you'll get. But there is constant talk that there's going to be a crackdown on individuals who've got these sticks. So I get offered them all the time. People are like, "Oh, do you want one of these sticks for your TV?" And I'm like, "No, because my whole career is based on the fact that
it's not a good look.
It's not a good look. It's not a good look for me to get caught." One of my best friends a few years ago, was moving house. So this is a best friend who I've been friends with for 20 years now. Was talking about buying some new dining room chairs online, and she was like, "So you can just go on these websites in China and you can send them a picture of a chair, right? And they'll just like make you as many as you want." And I was like, "Sam, that's my entire job. That's my career."
We'll just bleep that name out in the editorial.
Yeah. You can just give us the name. And,
we've talked about this for about 10 years, but she was just looking at it as a consumer, as somebody who wanted chairs, and we laughed about it, and that's it. But it's just so yes, there are punishments, for copyright infringement, and then there's obviously a civil liability. So for any IP infringement, when we take action, what we're always looking for in the first instance is what you can get if you went to court, which is costs, damages, interim relief, further and other remedies. There's always what we say. We always ask for publication and dissemination of the judgment. So our client wins. We ask that the defendant pays to publicise the fact that they've been an infringer. All of this. But then actually, what we find a lot is that what clients want is something different. So a commercial result for a client will be something different, and it might be something that you wouldn't get at court. So then we always try and settle. And of IP claims that begin, about 5% of them will issue proceedings at court. So most of them settle through pre-action correspondence, or they don't go ahead, whatever. Only about 5%, and then it's a very, very small percentage that end up at final trial. A lot of cases will settle before trial. So I haven't been to a lot. I'm not at trial every week. Couple of times a year at most, I'll be at trial. And trials take a long time to come round. So you're looking at like at least 18 months from issue to final trial minimum. We did we did a speedy trial once where we got an order for a speedy trial, and from start to finish it was 3 months. So everything was done in 3 months, but it was very truncated and it was very time intensive. There was a reason for it. We had issued for an interim injunction. So something you can get is if somebody is infringing you and there is immediate damage to your business, you can go and get an interim injunction, and the court will say the other side has to stop until trial. There are downsides to it, because if you then get to trial and you lose and you've got an interim injunction, you will normally have had to give what is called a cross undertaking as to damages. So you will have had to say, I want an injunction, but if I am wrong, I will pay you damages for the time that you have not been able to sell your product or do whatever you are doing. And they are very expensive to get, interim injunctions. So we went for an interim injunction on this case we had. The defendant said, we will stop selling, but actually we will stop. We'll compromise the injunction, but we would like a speedy trial so that this is dealt with in 3 months. And the court said, fine. So you can do that. But normally you're looking at a long time to trial. It's expensive, but most cases settle. And if they issue proceedings, they will normally settle before trial. And we've had many cases where actually what clients want to resolve matters is not something that you can get at trial, but quite often the other side, if we're the claimant or we're the defendant, is happy to agree that. Mm-hmm. So you will quite often get settlements where it's nothing like what a court could order, but ultimately if the parties are happy, that's the main thing. And sometimes that can be, you know, if a defendant's a big business, they might say, well, look, we've sourced this from China. We've gone to China to source this. We'll stop sourcing it from China. We'll buy it from you. And if they're big business, the client's going to think, great. Mm-hmm. And it can resolve that way. So it just depends. But there's always, we always try to recover costs for clients, and a lot of the time we do. But, and this is a depressing fact, but you should never go into suing somebody or proceedings thinking you are going to come out up in terms of money. Yeah. Because actually the court says you should be put in the position you would have been in but for the infringement. And normally general cost recovery is 60 to 70% on the standard basis. In very general terms, it's about that. So you are always going to be a bit down. Mm-hmm. And a lot of the time we have clients who finish and they think, well, great, I've won, but actually it's a lot of management time, it's a lot of expense. Would I do it again? I don't know. But then you see them further down the line and actually they say, I didn't see the benefit. And there's a lot of good publicity that comes from winning. If you have been copied or infringed and you sue someone, mm-hmm. you won't be copied or infringed again for a while usually. Yeah. So we have clients that come to us and they do a campaign where they'll think, right, we're going to take on everybody for a while and we'll sue one. And then I don't need to see them again for years because nobody will touch them. Mm-hmm. Because actually they think, I don't want to get sued. So there are big benefits. Yeah. We had one business who, and they won't mind me saying this, they won a big case, and it had taken a lot of time and effort, and the managing director said afterwards, oh, it was great because the first defendant went bust, couldn't supply the second defendant anymore, and now we do. And it's a huge amount of business every year. So it's actually worked out really well in the long run. Mm. But it's not an easy thing to go through. It's not, you know. So again, that's why early contracts, like having the early stuff in place, knowing what your rights are, and having good contracts and things like that in place with people you're doing business with, keeping records, helps get early settlements. So if you are copied, you can say, well, I've got this evidence, and actually if it's good, the other side won't want to argue because they're going to ultimately lose. Mm-hmm. So you're better off to do those things in the early stage. Yeah. Even if you are then copied, we'll solve it quicker.
Yeah, it's funny because I've just, on a personal level, not through the business, been involved in some solicitor stuff. And it was all just pre-action. We didn't go to court. But I hadn't really put the two and two together, but I think about it logically, our experience of working with you on our issue.
Yes.
And you know, just understanding the importance of the paper trail. much more quickly than I would have done in the past.
Yeah.
I started a paper trail on this
Yeah.
before, which turned out to be invaluable.
Yes.
So like, even though I was having conversations on the phone with the people that were involved,
Yeah.
there was 2 different parties. I would then follow it up with an email
Yes.
to have a written record of, as we just discussed, so on and so forth. And it all turned out to be very useful, yeah.
I keep everything, and I put everything in writing as well. And people hate it now. Like, sometimes I'll even if personal things, I'll send emails and they'll go, "You don't need to email about this." And I go, "Oh no, it's
I'm not going to sue you.
It's fine, don't worry.
If you don't come to the pub, I'm not going to sue you.
I do need to email about it, but don't worry about it. It's fine. I don't mind doing it." And I think to myself, I keep everything. Our IT people go mad with me because I've got like 40,000 emails in my account, and
it's all just space on a
It
cloud
is,
farm
it is.
somewhere. Don't worry about it.
But they used to go mad because it used to slow down the whole system before we moved. And I just used to say, well, I can't get rid of them. We might need them. You know,
Exactly.
they might come in handy. And they do. These
yeah.
paper trails, they do come in handy. And that's a big difference that we have here is if you are ever, unfortunately, in litigation, one of the stages is disclosure. And so I will go to my clients and the other side will go to theirs and say, you must disclose anything that helps your case, that hinders your case, anything you've got that's relevant. And normally we have a list of what we sort of have to look for. We need to see it. And the problem that people who have copied have is they don't know what they are doing legally wise. So clients or the claimant will always say they'll just delete the relevant stuff, and you kind of think to yourself, they won't, because they're not that clever. They don't know what they're doing. So what invariably happens is they will find everything, send it to the lawyers and go, well, I've got this, but I don't want to disclose it. Well, the minute that a lawyer has seen it, it cannot be destroyed and it cannot be withheld. Mm-hmm. A lawyer has to disclose it, or they have to stop acting and come off the record and say, I can't act for that client anymore. So we've had cases where it gets to disclosure and there's been denials and denials and denials, and then in one of them there was an email that said, it was to their manufacturer in China from the defendant.
Let's nick this.
Said, go and look at this website and get ideas for ranges, particularly like these 2, but don't copy. Just look at it. And then actually exact replicas had come out.
Yeah.
So, and you can't argue with that. But actually what had happened was the defendant had said to his lawyers, you come down and you do the searching for me. And the lawyers will not hide things. They are honest. So, but in some countries, there are not the same requirements around disclosure. So France, for example, and this is something we've dealt with quite recently, they have a program where before you go ahead, you will go to court and get an order and send a bailiff in to do a seizure of the defendant's premises, and they will look for anything that's relevant, because it appears that it's more common over there that documents are destroyed. So that's why we do these seizures. So it varies, but we in this country have stringent requirements, and quite often disclosure's great fun because the things that come out of it can really be helpful.
Yeah. Well, yeah, again, as I say, we didn't go to court, but on this personal thing, it was, 2 or 3 months in, we then saw email, because there was basically, as I say, there was 2 parties involved, one of which was an estate agent. And seeing some of the emails that they had been sending to the guy, which, we didn't see for months, but like we knew that something had gone on. Then you actually see it and you go, all right, so on that day you did actually completely lie about what we'd said. But like, it all comes out. But I was thinking also about our case, again, not case, we didn't go to court, but our issue.
Yes.
It seemed pretty clear. I'm not suggesting anyone destroyed anything, but just following the paper trail, there was an obvious gap. You could pinpoint the dates where a conversation had happened, where someone had said, oh, have a look at this. You just could, because there was an obvious gap.
And the court will draw inferences from gaps that are there. So there's 2 options when there's gaps. You can go to court and say, you can go before a judge on an interim application and you'll say, there are obvious gaps here, please. What we would like is an order for specific disclosure of these documents. And then the defendants might say, I haven't got them. They're not within my power, custody, control. I can't get access to them.
Like Rebecca Vardy, the phone just fell off the boat.
Yeah, that was great. That was really interesting in respect of expert evidence, because they both had experts who said different things. And Rebecca Vardy's expert didn't even seem to believe her. So what he said...
But it was such a believable story.
So what he said was her explanation for how a lot of the messages had been deleted was one possible explanation. It could have happened. And then Colleen Rooney's expert stood up and said, it could not possibly have happened that way, and I will explain why, because of the process of how WhatsApp messages are stored and, you know, archived and all the rest of it. And he went through it, and the judge said neither was wrong, but he believed Colleen's expert.
I think this theory may be put to the test again imminently, because from what I understand, whatever Boris is handing over to that inquiry,
similar.
He's claiming, oh, well, I changed my phone at a certain point.
Yeah.
But it should be relatively, from what I understand, irrelevant, because it's WhatsApp that's storing the stuff in the cloud, isn't it?
Yeah. So it's really interesting point, and the Vardy thing was, you know, great. There's been television dramas about it since, which I did watch actually, and I quite enjoyed. So, but it's that to be fair, as a lawyer, and it can be fun for clients, but actual trial, civil trial, is such fun. It's just like television. It is such good fun, and you can go and watch it for free. You can go down to court and watch trials for free. Go and watch them, because it's better than television. It is such fun. It's brilliant. We had a trial at the end of last year, and some lovely clients of mine who I've worked with for a long time. They were both the main witnesses, and two young guys who've done incredibly well. And one, Felix, he'll not mind us saying it's a published judgment. He was nervous about giving evidence. You know, because it's a nerve-wracking thing to get up on the stand.
Yeah,
it is a nerve-wracking thing with a judge sitting there, and everyone's, you know, fully robed hearings, wigs and gowns, fully robed. I don't wear robes, but the barristers all wear robes, and there's a lot of people there. And he was nervous, and he was the main one who was going to be cross-examined about his design. And he was really thinking about it, and you know, you could see he was nervous. And he got up the next day, and the other guy had gone first, because we thought if he saw his colleague go first, that might sort of calm him down. And he stood up, and he was just it was just a different person had stood up. It was just like somebody had flicked a switch, and he was amazing. And our barrister just opens, because in civil cases your witness statement is your evidence in chief. So all he says is it right? Do you want to correct anything? And then he sits down. And then the cross-examination starts. And our barrister turned around at one point and went, big game player, evidently. And it was just, it's things like that happen. And it's just, and sometimes you get these moments where it's just like this is like the smoking gun moment in the trial. And it's just great, such great fun. You know, we had a case years ago where there was some really heated cross-examination. It wasn't heated, but it had gone on for a long time, and the defendant wouldn't answer the question, and he kept skirting around it. And the barrister asked it 7 or 8 times, and he got to the point where he said, I will say it again. And the judge said, you need to answer the question. And he said, would you have done this? If it was you on the other side of it, would you have done it? And the guy couldn't say yes. So he had to say, well, no, obviously not. I would never give anybody that sort of information. And that was, and the judge actually said, do you understand what you've just said? And then our barrister was just like, right, we can move on now. And then we
cut to the advert break and then come back for the final.
Yeah, but it's such good fun. Yeah. It's such good fun.
I might have to go and
go and watch
have a look at that.
Criminal proceedings at the Crown Court.
Yeah,
they're really good fun as well.
Presumably more likely to be depressing though.
Can be very depressing. Yeah. Depends on what you see. I've never been and watched anything that was particularly horrific. But you are more than, and sometimes for the big trials in London, the queue for the public gallery is ridiculous. You can't get in. Yeah. In the know.
Well, I've got loads more questions, Kelly, but we're running out of time.
I'm sorry, I've prattled on.
No, you haven't. That's how we like it here. We'll have you back.
All right.
You can be the first returning guest on the podcast. Well, just as the last one, do you want to just tell a little bit about McDaniels itself?
Yeah. So McDaniels was, when was it set up? 2005? Yes, by...
Same year as us.
Yeah, that's good. Well, there you go. How are you celebrating it? Because you're coming up to... What?
Just had our 18th in April.
Yeah.
We
Had a first pint.
We talked about having a party, and then it got a bit too much to organise, and we're like, we'll just do something for the 20th.
That is what happened.
Maybe we should have a joint 20th then.
Yeah, definitely.
That'd be good. No, so it was set up by Neil and Rosanna Head-Rapson in 2005, who had both been lawyers in the city originally, but Rosanna's from the northeast, and people from the northeast return at some point.
The great remigration.
The remigration. So she had done that, and Rosanna was a family lawyer, and Neil was an IP specialist. I joined the firm. The first time I came to the firm was in 2007 to do work experience, so the firm was still very young at that point. And then I came back as a trainee in 2008, and it was Neil who trained me. So he trained at what was Gouldens in London. So yeah, and we've always been a niche business. The family side of the firm doesn't exist anymore because Rosanna became a judge, so she now sits as a full-time judge. That doesn't exist. I've always specialised in intellectual property, and because we are a specialist IP firm that works with the creative industries, we were allowed to move to the Northern Design Centre a few years ago, which was a great move for me. I think that's been the best thing that happened, because it's so nice to be in a creative hub and community. And all we do, pretty much, most of 95% of what we do is IP. We do related work as well. We will do commercial related work, anything contract related, pretty much, we will happily take on. And we have affiliates who do other areas. But we work with a great selection of clients, so from down to like micro enterprises, individuals who work by themselves and licensed designers, things like that, up to sort of PLCs. There's a full range, and it's really interesting and varied. And so then in 2023, in April, things changed in the business, and I became the managing director, and Neil's stepped back, so I've taken over now, and he's a consultant. And I'm in charge, which is nice change.
How are you finding that one?
Good. It's good. It's different because it's a bit like when you first qualify as a lawyer, you just worry all the time, because you're still learning. You worry about negligence, you worry all the time, because you're like, must get this right, I must do it right. And it's a bit like going back to that, because becoming a business owner, then you're starting again. It's a new thing again, but it's quite nice and exciting. And it's not quite the same, because I've been involved in the management for a lot of years, so it is different.
Well, I was going to say, in football, they say that one of the hardest moves to make is to be a player manager.
Yeah.
Because you go from being one of the lads to suddenly one of the lads plus the boss the next day. So how's that transition been going?
It's all right, because I've kind of... Neil's obviously been in charge for a long time, but I've always sort of sat just beneath his level anyway, and I've been a bit of an intermediary for a long time, and so it's all right for me. The staff might feel differently, but we're not a big firm. We're quite a close-knit firm, and this building's quite close-knit in a lot of ways, and a lot of people know each other. So it's been good so far. It's a lot to get used to. And the stresses of going through that procedure of taking over actually take up a lot of your time and diverts you away from things. So it's nice now to be back to doing sort of IP. And we go to a lot of trade shows because we have clients who are nationally based. So we go to a lot of trade shows.
Or you just walking around just tucking your business card in people's shirt pockets?
Yeah. Well, they are sort of... A lot of people at trade shows tend to want IP advice as well, so it works really well. And we're at the stage now where we've got two this month and then one next month. But it's always nice. It's nice to go out and see clients in the flesh, face to face, and have a coffee with them at these things and talk in person. So we always enjoy that. So I'm quite looking forward to that. A lot of them are in the NEC, which I don't look forward to because that's just grim. But there's a lovely one in Harrogate, which is in July, and it's outside, and you can go to Betty's and get like cakes.
I knew you were going to say that.
Enough, yeah.
I knew you were going to say.
Have a slice of their version of the caterpillar cake.
Yeah, you've got to love
Cecil.
Betty, so it's good, Betty. Somebody's got a Cecil. Somebody got a Cecil. I feel like somebody's got a Cecil. Yeah.
What a guess.
Yeah. Percy
Don't
Pigs.
come after me.
There was a nice thing in the paper about Percy Pig a couple of weeks ago. Again, we did an article on it where somebody in
I think I saw this. Did someone bake a cake or something
ice
like
cream.
that?
We're putting it in
Yeah.
ice
Oh,
cream.
ice cream, that was
And,
I saw it as well. Yeah.
Marks and Spencer sent a very nice letter explaining why they couldn't allow that. And there's an argument from an IP perspective that you could say, well, actually, it's what's called, it's descriptive use. It's factual because there were Percy Pigs on the ice cream.
Yeah.
But the problem with that is, without a doubt, Percy Pig, well, it is a registered trademark, but it has a huge amount of goodwill in it. And would consumers think that was in some way linked to Marks and Spencer? Arguably, yes. So, and they wrote a very nice letter about it.
Yeah, the letter was very explanatory.
Yeah.
Most importantly, it just had the right tone, didn't it?
Yeah.
It was firm, but it was
Yeah.
like, look, we know what this is.
Yeah.
We know you're not trying to
Yeah.
come on. That was basically the letter. That was the letter.
Yeah, you do.
That was the letter.
And you do get these instances of,
They came out of that with good PR.
Yeah.
That's the thing about it. They
Yeah.
maintained their protected their copyright, their trademark, but came out of it and everyone's like, hey, good on you, Marks and Spencer.
and you do get that. You get businesses trying to trade off each other's bad PR on IP. So there was a guy who had a corner shop and he called it Sainsbury's.
Yeah.
I think he called it Sainsbury's, and then Sainsbury's sent him a snotty letter, and then Morrison's wrote to him and said, call it Morrison's. So he changed it to Morrison, and Morrison's then looked great, but they just thought, well, we can jump on the back of that and get some publicity off it, so they did. So
well, thank you for
You're welcome.
being a guest on the
How was it?
podcast.
good, yeah, good.
Yeah, it was really
Good.
interesting. I hope everyone got something out of that, because it's, like you said at the beginning, it's not something people want to think about.
No. And
No,
it's
but
really complex. You could talk about it for hours, which
Yeah.
nobody wants to hear. I'm fully aware.
But it does sound like something that with on paper, quite simple steps you take up front,
Yes.
i.e., I'll look at your contract,
Yeah.
think ahead, basically think ahead, look at your contract, establish a paper trail, particularly if you're doing what we're doing, generating creative ideas, creative endeavour of any kind. And as long as you do those things at the start, you're giving yourself a much better platform.
Much better chance, yeah. And know where you can get some help. So, like ACID, for example, just as a trade organisation, let all their members use their logo and put it on anything they want, their website, their stationery, anything, products, whatever. And the message that sends out, though, is that actually you're part of this organisation that educates people about IP, and you've got access to free legal advice on issues, and you're in a community that lobbies government to change IP law, and it makes a difference. It makes a difference. So if somebody can see that, they'll think, oh, is it worth me copying this business? Because actually they'll probably come back at me for it. It does help, but then also it gives you access to come and speak to solicitors like me, who can then tell you what you should be doing to firm up your rights.
Yeah. All right, yeah, we'll make sure we've got the details for ACID. I know
But you
it's
can
an
ring me
acronym,
anyway,
but-
because you're only upstairs, so you just come and
Yeah,
knock on the door.
yeah,
It's
yeah.
all right for you. You
Yeah.
probably can get away with it.
So thank you for watching and listening. Do you want to do
Yes.
your outro, Matthew?
No, you can do it this time.
No, honestly, this is great. Go on.
Go on then.
I just haven't got the bottle to do it. That's the
I
difference.
haven't got the bottle to do what?
Go on. Your
Well-
thing. It's your thing now.
Well, okay, so let's talk about this in copyright terms. Is it the words that I'm saying, or is it the artistic expression that I use
it's
to...
everything.
It's the whole
it's
package.
It's the fact it's you more than anything else.
that's what it is.
And your trademark.
It's the fact that he's figured out a little chink in the armor where So what he wants me to do is to remind everyone to smash that like button and that subscribe button, and that's all he likes.
There you
just
go.
likes that, yeah.
Excellent. It was good. I enjoyed it though.
Well, thanks.
Such
you.
conviction.
Thank you, and thanks for coming. Thank you. Appreciate
No,
it.
it's been good.
Yeah.
Thank you.
Bye.